Sim. Tramite nešto niti loše uradili ovo.
Da vidiš njegov taj link.
Pa evo ko ovde, nego trebalo bi već da počnu, sad je pola da idem da vidim.
Samo mi to treba da promišljam. Cleveland Board of Zoning Appeal. Please mute your microphone.
Čekaj da vidim.
Mislim da su ovo brali.
Morning, everyone. Welcome to the Board of Zoning Appeals. We will start with the preamble.
Good morning. My name is Liz Kukla. I'm the Secretary of the Board of Zoning Appeals, and I'm going to read the preamble for you this morning, this Monday, June 29th, 30th. In compliance with notification requirements of the city's open meeting law and section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the city planning department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair facilitator to recognize you and be sure to select to unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that call-in users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak on a particular case via our website and email. All requests to speak on a particular matter have been considered. We have also received emails from those who have provided written comment on a particular matter. Back to you, Madam Chair.
Thank you. We'll call the roll.
Ms. Holzer,
Present.
Ms. Faith,
Present.
Mr. Madison,
Present.
Ms. Wilson will be absent this morning, and Ms. Roca.
Present.
Madam Chair, this morning you have 4 members present, and we should state for the record to the applicants that with 4 members present, you run the risk of your case being denied if there is a tied vote. A tied vote essentially means a denial. So at this time, the appellants can request a postponement to a future date when we would have 5 members.
Are there any appellants in the room or on the phone who would like to postpone today based on the membership of the board? Not seeing anyone? All right, we will proceed. Do we have any postponements or withdrawals?
We do have several postponements this morning. I'll start with calendar numbers 25-090 at 1347 West 69th Street and 25-0191. This is in the same project. The applicant had a scheduling conflict, so we were able to shift his date to July 7th. So he will not be heard this morning, and letters have already gone out notifying neighbors that this has been changed. July 7th.
Sounds good. Any other postponements or withdrawals?
So the next one is calendar number 25-082 at 4281 West 130th Street. Pure Market Inc., owner proposing to erect 6 fuel pumps and establish use as a motor vehicle service gas station in a C1 local retail business district and a riparian wetland zone restoration riparian setback. Madam Chair, we received the request from the future council person. He's going to be future due to redistricting. He is here today if you wanted to speak with him. He would like to hold his own public meeting on this, so he's requesting more time. I also believe there are representatives from the applicant team as well that might want to have make some comments. But
Has this been postponed before or is this?
this is the second postponement.
Okay.
The first postponement was by the city to allow time for the applicants to put together a mitigation wetland plan. And for the record, we did receive a site plan, but we did not receive a full report. So the city would have likely asked for more time as well because from what we received, it didn't look like it was fully fleshed out. We didn't have all the information that we needed.
So do we have the wetland mitigation plan?
At this time, we just have a site plan. We didn't have any report from a wetland professional or any sort of narrative that generally comes with, something written up that generally comes with this type of project.
Okay. So without giving testimony, because no one's been sworn in, Councilman, would you like to state why you're requesting a postponement?
Sure, since the last, public meeting, we've just learned of the new board boundaries, so I'll be picking up this portion of the city, starting in January. So I'd like to have the opportunity, I'm sorry. So I would really like to have the opportunity to vet this project further, hold public meetings and do our own due diligence, moving forward.
Okay. And is the appellant in the room? Yes, back there?
Yes.
Okay. So, sir, it sounds like we're still missing some documentation from you. And we're gonna take this to a vote for a potential postponement, but we will need to get a wetland mitigation plan to Ms. Kukla. Are you prepared to submit that?
Yes, the environmental design group is working on that.
Okay.
Professional. What I dropped off on Friday was the basis of it, just to make sure we was ready for today.
Okay.
So I alerted them of the postponement request that I learned on Friday.
Okay.
Councilman Casey and Ms. Kukla. So it would be.
Okay, and let me just get your name for our court reporter, sorry.
Julius Tate.
Julius Tate. Okay, thank you. All right, so it sounds like we have a postponement request on the docket here, and we'll take it to a vote. Ms. Kukla, can you call the vote, whether we can?
Oh, I'm sorry. I was waiting. Sorry. Yes, Ms. Holzer,
Yes.
Mr. Madison,
Yes.
Ms. Faith,
Yes.
and Ms. Roca.
Yes.
Okay, so this case will be postponed. No testimony was taken this morning. The new dates, August, we're thinking more than 30 days might be the best to give them time for a
that enough
public
time?
meeting.
For me, the longer we push it out, the better.
So,
We object to that. We've been going now for almost a year. We held 2 of the required public meetings and invited both Ward 16 and Ward 12 to be present. So we would like it to be 30 days.
Madam Chair, look, that's not just for my well-being, but they don't even have their own study done yet. So I would definitely make sure that
Able to get your
they have enough time to
mitigation
get their
plan together
study.
in 30 days.
Yes.
okay, so we are.
Will you
looking
be
at-
able to hold a public meeting in
I'll-
30 days?
I'll do what the board asks.
Do 30 days.
So July 28th approximately, or if we want to push it another week, that would be August 4th.
I would say August 4th.
Okay, so calendar number 25-082 is postponed to August 4th. We will send out a letter again 10 days before the hearing alerting neighbors of the new date.
Thank you all for being here.
Thank you.
Ma'am?
But you know that Councilman Casey, he didn't know, he just told you, he did not know about the zoning. He's been knowing about the zoning ever since we started this process. For the record, to let the record know that Councilman Casey has known about this zoning process and coming here to the zoning board for over 5 months. He attended one of our meetings.
And what's your name, ma'am?
My name is Gilda Malone. I'm part of their planning crew, community outreach.
Okay,
Make sure that we can have a grocery store.
all right. Thank you for your comments. We don't have you under oath right now, so we're not going to let you testify. But it is to be noted for the record that the appellant still has to submit documentation that has not been submitted. So that's further indication to the board as to why we need a postponement. All right. If you're here for this case, it's now been postponed. So unless you want to stay with us for several hours, you're free to leave. Thank you. All right, well, we will start with the top of the agenda then. Moving on to calendar number 25-076. Ms. Holder, will you please read in the case?
Sure thing. Our first case is calendar number 25-076. This is at 153174 Chatfield Avenue. This is a violation notice. Lucas Storage or I should say it's an administrative appeal of a violation notice. Lucas Storage LLC owner appeals under the authority of Section 76-6 of the Charter of the City of Cleveland and Section 329.02D of the Cleveland Codified Ordinances from the notice of violation number V250-12213 issued on April 15th, 2025 by the Cleveland Department of Building and Housing for failure to comply with Section 327.02C of the Cleveland Codified Ordinances, which states that there shall be no change, substitution, or extension in the use of any building or premises until the required use permit and certificate of occupancy has been issued by the Division of Building and Housing. The appellant must submit plans to obtain the permit to establish the use of a storage interior and exterior. And with that, Madam Chair, who will be doing the oath today?
Mr. Madison will be doing the oath today.
All right, I will hand it over to Mr. Madison for the oath.
Thank you. For all those who are present and would like to speak on this case, can you please raise your right hand and please repeat after me?
Javi se.
Okay.
Do you hear?
Can you hear us? This is Mike, the owner.
We can't hear you. We're going to swear you in. Just give Mr. Madison a moment to administer the oath.
So thank you. So at this time, please repeat after me and raise your right hand. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please state your name, say I do, and your address.
I do. 15317 Chatfield Avenue, Cleveland, Ohio. Mike.
What's your
Mike-
name, sir?
Mike Panderovic.
Can you spell your last name?
Pandurevic.
Thank you. And is the individual next to you, will they also be joining and speaking on the case?
Yes, that is my wife.
Hello.
Thank you. Can you please raise your hand and reply with I do and state your name as well?
I do.
For the record.
I do. My name is Dragana Pendurevic.
Can you please spell that for the record? Oh.
First name is Dragana and last name is Pandurevic.
Thank you. Is there anyone else present that would like to speak on this case that needs to be sworn in?
No.
All right, thank you. I'll turn it back over to you, Madam Chair.
Thank you, Mr. Madison. All right, any history that we need to be aware of, Madam Chair? Or Madam Secretary?
Madam Chair, no, we generally do not do research for these cases. And I would just state, though, that we did add an extra number on the public record. It looks like the address is actually 15317 Chatfield Avenue, not 153174 as was posted on the agenda. So I'd like to make that clarification for the record.
Thank you for that clarification. All right, legal standard, please.
Madam Chair, members of the board. Let me see. Okay. Appellant is appealing a violation notice issued by the Cleveland Department of Building and Housing. The standard of review is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
Thank you. All right, we will hear from the appellant now. Is there anyone here from the city on this matter?
Shannon Leonard, Chief Zoning Administrator.
Okay, great. Thanks, Ms. Leonard. All right, we'll go ahead with your testimony to the appellant.
So this applicant, give me 1 second, please. So this appellant, I don't know the exact circumstances of the ticket, but I do know that they have been here for quite some time. And I believe they've had this carport for quite some time. They'll have to give the testimony on that. But they have put in an application to essentially park their trucks under this carport. And so they are permitted to do that use at this location. I believe it's light industry, industrial here. And so I'm not exactly sure about the violation notice itself. I think it's that they just had never gotten a permit for it. And so they have since put in a permit and the zoning for that has been approved. Pending-
So, thank you. So is this matter moot then, Ms. Leonard?
I don't have the exact details from the applicant themselves, but essentially I believe it is.
Okay, well, we'll hear from the appellant. Sir, would you like to provide your testimony?
Well, whatever I need to do. I mean, what would you like to know?
So what is are you seeking to park trucks under your carport, and have you submitted a permit application to do so?
I didn't understand. I didn't know that I had to do that. I thought it was understood because I bought the property for AT&T and they used it for that same. So I didn't know that I would have to get a permit. But you know, if that is what I need to do, that is what I'm seeking.
Excuse me, Madam Chair, I'll also mention, as Shannon stated, the applicant has submitted a permit for the change of use to warehouse for 14/25 this year.
Or, I'm sorry,
For 14, April 14th.
oh, April 14th. Okay, so the permit is still under review?
I think Shannon Leonard just mentioned that they finished their zoning review and
Okay.
it was complete.
All right, so it sounds like this matter might be moot because you have submitted a permit application for the change of use, and the department has reviewed your application, and I don't believe that we have a dispute on that at this time. So from a procedural perspective, Ms. Kukla, I think that what he can either withdraw or we could dismiss. Okay. So sir, would you like to withdraw this appeal, seeing as how you don't seem to need it? We can do that, or we can dismiss your case. It's up to you.
Well, I just want to be legal. I want everything to be legal, and that is my whole goal. I'm not understanding the technical wording that you're using, but we just want to be able to use the property to do what we bought it for.
Ms. Leonard, I see your hand is raised. Go ahead.
Yeah, so maybe I can clarify. So normally what happens is when you buy a property and you open business, you have to get an occupancy permit.
Okay.
If it's the same type of business that was there previously. It's called a transfer of occupancy permit. And I think
Okay.
that's what we're doing here. And so that was why they wrote you a violation, because you had not submitted a building application to get an occupancy permit, but you have done that since this violation notice was written. And so the zoning for that has been approved. It just this part needs to get through BZA. And then building will issue the occupancy permit to you for the use.
Very good.
Assuming-
So I'm to assume that we can do what we want to do, like the park vehicles and stuff, use the warehouse.
Yes, sir. You can definitely still do that. The prior occupant did the same as you had
Yes.
stated.
They have been doing that for the last 40 years.
Yeah, I would just recommend a dismissal, Ms. Roca.
Okay, great. Do I have a motion to dismiss this case?
So moved. I'm sorry.
Yes,
Go-
go ahead.
go.
That's fine.
Board Member Madison moves on the motion.
All right, Member Madison has moved to dismiss the case. Do I have a second?
I'll second that.
Thank you, Ms. Faith, for the second. Ms. Kukla, can you call the roll?
Ms. Holzer?
Yes.
Ms. Faith?
At me,
Yes, sorry, Ms. Faith.
it broke up. Yes.
Mr. Madison?
Yes.
Ms. Roca?
Yes.
Counter 25-076 is dismissed with the understanding that the applicant is in the process of acquiring that permit.
Great. Thank you for joining us today. And your case has been dismissed, and so you should be good to go to work with the city on obtaining your permit.
Very well. So I would get a hold of the city and ask for an occupancy permit. Please, I mean, what if
So my recommendation is, Ms. Leonard, are you still on the call? I don't see you anymore.
It looks like she might have had some connection issues, but that's correct. The permit's
Can
already
you
in.
advise him on who he should speak with?
Basically, you just wait. You should get some kind of response from the city stating that your permit's ready to be pulled.
Very good. Okay, very good. Thank you very much.
Thank you. Have a great day.
Thank
you.
you. Bye-bye.
All right, we'll move on to the next case, which is calendar number 25 -087. Ms. Holzer, if you'd like to read that in, please.
Sorry, excuse me, Madam Chair. I just wanted to also mention that you'll be notified that there's I think if the previous applicant's still on the call. Okay, I'll follow up with them afterward. I forgot to mention that there's fees involved that they'd have to process before they're able to pull the permit, but I can follow up after this call to make sure they're aware. Thank you.
Great, thank you. All right, on to the next case.
All right, our next case is calendar number 25-087. This is at 16704 Erndale Avenue. Karen Stacy Newson, owner, proposes to erect a one-story frame bedroom addition attached to an existing attached garage of a single-family residence in an A1 one-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances stated in the agenda and the public record, of which there is one. And with that, I will hand it over to Mr. Madison for the oath.
Thank you. Is there anyone present in the room today that would like to come forward to give testimony? Please come forward and please hit the mic as well. That way your mics are on and turned on to green. Is there anyone online as well that wish to be a part of today's conversation?
Yes.
Okay. Well, I'm going to swear in the individuals that are present, and I'll come over to you. Please raise your right hand and reply after me. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please reply with I do. State your name and address for the record.
I do. Karen Knudsen, 16704 Ernadale Avenue.
And can you please spell your name as well?
Sure. K-N-U-T as in Thomas, S-O-N.
Thank you. Is there anyone else in the room that would like to give testimony? Please come forward.
We'll have you hit that other mic too.
Thank you. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your right hand. State I do.
I do.
Your name?
Mitchell G. Dysart, D-Y-S-A-R-T.
Thank you.
Y-S-A-R-T.
Correct.
And moving to online, please raise your right hand. Do you swear and affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please reply if I do. State your name and spell it for the record, please.
I do. Brandon Young, 15614 Detroit Avenue in Lakewood.
Thank you. I'll turn it back over to you, Madam Chair.
Thank you, Mr. Madison. We'll have a history of the property, please.
Thank you, Madam Chair. There's been no change in the zoning since 1929. In our Records Administration Office, we found that in 1923, a permit was issued to erect a dwelling in a garage. 1952, a permit was issued to erect a frame attached garage. And then, Madam Chair, there are no variances on file. And we do see that in the more recent history that there are HVAC, electrical, and other such permits issued to the property. And it looks like a generator, maybe an earlier this year. And that's all that I have, Madam Chair. Thank you.
Thank you. We'll go to legal standard, please.
Madam Chair, members of the board, appellant is requesting an area variance from the interior side yard requirements of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
Thank you. All right, we'll go to the appellants. Let's hear about your project.
So moved in a couple of years ago, not quite, maybe a year and a half, and I love the property. I love the neighborhood. But it is it's a little small for the people I've got living in the home and working in the home. And I wanted to kind of expand, like do a number of improvements, but the one we're here to talk about is adding like a 400 square feet on top of the garage. I originally earlier this year actually like drew up plans to kind of move expand to the backyard, which wouldn't have required, building up on the garage. But after I hired an architect, paid for the plans, I made a mistake, actually. I had the GC come after all that was done, and the general contractor took one look at the access to the backyard and said, this won't work. I can't get the heavy equipment back there. So we went back to the drawing board, and we ended up developing a plan that just builds up on an existing garage. So that would add a lot of square footage. I think improve the look of the house on the outside. And I didn't understand about the variance until after we got kind of to this point. So anyway, first time here, I don't really know kind of what else you might need to know or want to know.
So do you have an existing garage?
Yes.
Okay, and so you're gonna just build on top of it?
Yes.
And is this gonna be a rental unit?
No.
It'll be part of the house?
Correct.
And is it gonna be used for short-term rentals at all?
No.
Okay. And how will you access the unit? Through the garage or?
Yeah, no, and if I may, it's going to be,
For the court reporter, you want to say your name?
I would say, yeah, my name is Mitchell Dysart, Dysart.
Thank you.
And it is on top of the garage, but it will expand an existing bedroom.
Okay.
So it's one large master suite.
And you will enter through the garage then?
No, you enter through the upstairs, just like you do the existing room.
All right. And Mr. Young, we'll go to you for your testimony.
Yeah, I think Karen spoke about what the purpose of it is. It's a primary suite addition. If we fulfilled the full 10-foot setback, there wouldn't have been enough space for a primary bedroom above the garage. So, and it's actually not structurally feasible. So, we aligned the exterior walls. So the existing attached garage is 5 foot, just over 5 foot from the property line. So I believe the requirement is for 10 feet.
And sir, are you the architect?
Yes.
Okay, thank you. All right. Anything? Go ahead.
I do have letters
Sure, go ahead.
One is from Maureen Kane at Marquis at 16705 Ferndale Avenue.
Ms. Kugler, your mic's not on.
Thank you. I'll repeat that, sorry. Maureen Keen writes this email from 16705 Ernadale Avenue. She objects to the appeal requesting relief from the application of the Cleveland Codified Ordinances, section 357.09B2. The 10-foot interior side restriction is there for fire safety and to ensure a safe distance between buildings in case of fire. I strongly feel that the existing ordinance has to be followed, not only for the fire safety, but it also maintains the overall aesthetics and property values of the neighborhood by adhering to the proper spacing required between houses. It's a nice thing if the owner desires to enhance their home. However, I believe and hope that she would have to do it in another fashion or some other direction so as not to infringe on the property next to hers. And that was Maureen Keene. And then here is another email from Catherine Jerub, who is writing on behalf of Alicia A. Gibbons, owner at 16704 Ernadale Avenue. Alicia A. Gibbons does not have internet or Wi-Fi and asks that she provides the attached objection letter to calendar number 25-087. Alicia A. Gibbons is unable to attend in person at the oral hearing as she is tending to her sister who is immobile and in bad health. Alicia A. Gibbons advises the proposal in calendar number 25-087 as it is a safety hazard fire risk and prevents airflow between the properties. And I will read the letter attached, although it is a photo of the letter. It states that, again, this is from Alicia Gibbons, "I strongly object to the appeal. The property is in an A1 residential district and the codes were put in place to prevent fire, et cetera, fire, I believe, and to protect her home, my home next door and all living on the street. When the attached garage was built in 1950s, the zoning board only allowed what is currently standing. The zoning board did not approve a second floor or more room closer to my home because of risk of fire and airflow and noise, et cetera. I repeat, this is an A1, one-family residential district, and the zoning district must continue to be enforced. Even a trailer park requires a distance greater than what is being requested. Sincerely, Alicia A. Gibbons."
Are those all the letter?
And that is it. Yes.
All right, thank you, Ms. Kubla. I'll go ahead and open it up to the board for any questions.
Yeah, so Madam Chair, just through you, I'll kick off the hardship question. If for some reason today the variance is not approved, can you speak to the hardship and difficulty this would mean to you or the work that you've already have put into place for this project?
Well, let me just state, it's important to me that I have good relationships with neighbors, right? So I knew Lee, the next door neighbor, her and I have talked about her concerns. I didn't know there was another neighbor who was upset, or I would have made a point to talk to them. In terms of hardship, I mean, we can live without it. But I really just want like a house that I think functions well for the people that are, you know, we've got 3 people, 3 adults living in there, plus 2 working from home. So it's a little small, right? And I don't want, I mean, to be honest, we could move, but I would prefer not to. I mean, I really love the neighborhood, and I feel like it's a great neighborhood in Cleveland, right? And I want to, I mean, by investing and staying there, I thought that was a great thing, you know. But I mean, but I want to reiterate, I don't want problems with neighbors, you know, especially lately with, you know, I don't know if you guys know, never mind. Yeah. Yeah. So, I mean, I would work hard to kind of maintain friendly relationships. I don't know. Is that, I don't know if that gets at what you were after, like what you were asking, if that actually answers your question.
And if I may, there's been a few $1,000s spent on architectural fees at this time. And the zoning variance request has to do with the setback from the property line, right? For fire purposes, it's probably a good 10 or 15 feet away from between these actual structures.
All right, great, thank you. Any other questions from the board? Mr. Young, I see you have your hand up. Go ahead.
Yeah, I would just state that, just to reiterate Karen's point that about the hardship, you know, we did study doing an addition off the back of the home, but due to access issues, getting equipment back there, it wasn't feasible. Even then, that would have been an interior, a side yard setback. I mean, the lot is only 50 feet wide. These are, you know, dense properties. In addition, I would note that, you know, we are 20 feet from the neighbor and 5'2" from the property line. In terms of fire, you know, that's a building code requirement, and it states that anything less than 5 feet is supposed to be a 1-hour fire rated assembly. So, in terms of fire safety, you know, a garage is much more hazardous than, or quote unquote hazardous than a bedroom addition that we're proposing. So, you know, we understand their concern, but we are meeting the fire code requirements.
Thank you for that, Mr. Young. Do I have any other questions from the board?
I have some questions, Madam Chair.
Great, go ahead, Ms. Faith.
Okay. I'm looking at, excuse me, I'm looking at the screen of the house now on Google Maps. And I'm interested to know, it looks like a flat roof garage as it exists right now. And if we go up, is the height of the building, I don't know, all I'm seeing is a plan view. Where is the height of the building going to fall? Thank you, Mr. Bay. What's the height of the building going to be, the new addition?
Mr.
So
Young?
you can see in the elevations here, the ridges will align. So the new addition will be the same height
Okay.
as the existing.
Okay, great. What's gonna happen to that tree that is, is it to the west of the garage? Is that on your property or
We're
the
not
neighbor's property?
proposing removing any trees. We actually have evaluated the existing foundation wall of the garage, and it is capable of holding structurally supporting a new addition.
Okay, so it has
keeping the tree.
adequate footers for you to be able to build that load on top of it?
Yeah, we did a selective demolition, selective excavation in the back of the garage, and we determined that the footers are adequate for an addition. Correct.
Okay. And where exactly is the lot line? Because I'm looking at that bump out on the driveway, sort of what looks like a parking pad. Is that all on your property?
Yes, we believe it is. Without having had a survey done, that aligns with the fence line in the back. And
Okay.
yeah.
All right, so you have, that answers another question. You have not had an actual professional survey done.
Correct.
We have not.
Okay. That is one thing that I absolutely think you should do before you proceed with this project. Because without knowing where your lot line is professionally, I think you're leaving yourself open to a can of worms. And how do we know we're really 5'2" from the lot line if we don't know if we have no civils to actually know where the lot line is? So you've got some pretty strong objections to this, and you have no civil drawings. The other thing that concerns me with that parking pad is you cannot park any vehicles within 10 feet of any openings on a building. So I don't know if you're using that for parking, but you're next to your neighbor's windows, and you're also adjacent to windows on your own building. Quite frankly, I would be much more comfortable for you to withdraw at this point and get your civils done and come back to us. I don't know what the other board members feel about that. And to the architect, we cannot, as BZA, we cannot require you to add additional fire retardancy to the structure outside of what's required by building code. But given the situation, I think it would behoove you to take the next additional step to add additional fire retardation to that building. That's where I stand, Madam Chair, at this point.
Thank you, Ms. Faith. Any other questions or comments from the board? Mr. Go ahead.
Thank you, Madam Chair. Yep. My name is Xavier Bay. I'm representing city planning. We would recommend approval because the applicant's just going upward in the development here. And as you can see on the site plan there, about 20 feet from wall to wall where the actual addition is being proposed. And so we don't see much wrong with the proposal. Thank you.
Okay, thank you. Any other commentary from Mr. Young or the appellants?
Yeah, just Madam Chair, just through you. I'm also looking at the Google Maps. When I'm looking at this, I'm just trying to make sure I have the right home. You guys aren't in the corner here, are you?
No.
Is it the second house into?
It's maybe about 4 or 5 houses down.
Okay, I see it. Thank you. I appreciate that. That's my only question.
Mr. Young, do you have any final comments?
Yeah, I would just state, you know, we can, in regards to getting a survey, you know, we are not proposing increasing the footprint of the building. So the property line, you know, if it's 5'1" or 5'4", I don't think that changes the project. You know, it's not like we can push that addition, you know, a couple inches in or a couple inches out. We're just maintaining the existing footprint and just going right over the garage with it. So projects where we are increasing the footprint further, that I think that's more important, in my professional opinion.
Great, thank you. All right, unless we have any other comments from the board, I'll entertain a motion.
Yeah, Madam Chair, I will move to approve calendar number 25-087.
Thank you. Do we have a second?
Board Member Holzer, I second.
Great. Ms. Kukla, can you call the roll, please?
Sure. Ms. Faith?
No.
Ms. Holzer?
Yes.
Mr. Madison?
Yes.
Ms. Roca?
Yes.
Calendar number 25-087 is granted. It'll be ratified next Monday. We'll send you a letter, but you can contact our office next Wednesday for further instruction.
Okay.
Thank you.
Thank you. All right, moving on to the next case. Ms. Kukla, so we postponed 090 and 091, correct? Okay, so we're on to calendar number 25-096.
All right, our next case, and I believe our last case of the day, is calendar number 25-096. This is at 2335 West 11th Street. Cleveland Property Rental LLC owner proposes to establish use as a professional body art tattoo studio and art gallery. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 2. And with that, Madam Chair, I'll hand it back. Oh, I will hand it to Mr. Madison for the oath.
Thank you. At this time, can you please just raise your right hand? We'll swear you all in at the same time here. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply with I do, state your name and spell your name for the record. We'll start with you.
Sure. My name is Chris De La Rosa, and the address is 2335 West 11th, Cleveland, Ohio, 44113.
Can you please just spell your name for the record, please?
Christopher is CHRISTOPHER. De La Rosa, DELAROSA.
Thank you. Move on to you. Please reply if I do, state your name, spell your name, and also the address.
Okay, I do. I am Kimberly Chen, CHEN, KIMBERLY, and my address is 629 Euclid Avenue, Suite 1703, Cleveland, Ohio 44114.
Thank you.
Yes, good morning. This is Attorney Richard Herman. I'm representing both Kimberly Chen, her corporate entity, Cleveland Property Rental, and Mr. De La Rosa and his business entity, Morningstar Art Collective.
Thank you. We appreciate that. Could you spell your name just for the record? You don't have to swear in as an attorney, as you know.
Sometimes I've been asked to do that. We assume everything I say might be true. Last name is Herman, HERMAN. And my office is at 408 West St. Clair, Suite 230, Cleveland, Ohio.
Thank you. With that, I'll send it back over to you, Madam Chair. Oh, wait, is there anyone online that would like to participate in today's testimony? Thank you. We'll swear you in as well. Please raise your hands. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? And we see that there's a couple of other people. If you're speaking on this case, please come forward. Online, please just reply if I do, state your name and an address, please.
I do. I'm representing Lemco Hall Condo Association. My name is Michael. Last name is Deyling. And the address for the condo association is 237 West 11th Street, Cleveland, Ohio.
Thank you. And for the two that just came forward, please reply with
Oh, yeah, turn your,
do
turn it on. Yep.
and state your name as well for the record.
I do. My name is Angelica Padron. My address is 2468 West 6, Cleveland, Ohio, 44113.
Thank you.
Sir, my name is Steve Canerum. Last name is spelled K-N-E-R-E-M. And my address is 14770 Sleepy Hollow Drive.
Thank you.
Sorry. I just wanted to clarify the address that I gave was the address to the business. Would you like me to restate my?
No, that's
okay. Okay.
Your mic is not on though. There you go.
Back over to you, Madam Chair.
All right, thank you. And we've sworn everyone in online. Is that correct? I'm not seeing anybody else. All right, history of the property, please. This beautiful property.
Thank you, Madam Chair. We didn't find a whole lot of records on this. I can tell you that the zoning hasn't changed since 1929. In our records administration office, we found that in 1919, a garage was added to this address. And in 1963, a permit was issued to erect 2 illuminated business signs. And then in the more recent history, we found there are no variances, but we also found that there was a certificate of disclosure issued in 2022 stating that the authorized use of the property is as a residential condo. And then again in 2024, August of 2024, the authorized use is as a residential condo. And that's all that I have. Thank you.
Thank you. And legal standard, please.
Madam Chair, members of the board, appellant is requesting a use variance and an area variance from the minimum distance requirements of the zoning code. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
Thank you very much. All right, we'll move to you to tell us about the project.
Good morning, Madam Chair and members of the committee. Thank you for inviting us today. I too am proud to be here to talk about the historic Lemco Hall. I used to live in Russia, in Moscow, and Lemco Hall was built by Russian immigrants, I think over 100 years ago. The intention of the building was to create residential units on the 2nd and 3rd floor and commercial units on the bottom floor, on the street level floor, to serve the public and provide services. As we also may know, you also may know the Lemco Hall was attracted to Hollywood, and Deer Hunter was partially filmed there. At this time, I'd like to submit to the board exhibits. And I brought 5 copies, so I'm not sure you're going to need all 5 copies.
We will need 2 copies for us.
Okay.
And then 1 copy for the secretary.
Okay.
You submitted them electronically?
I did not.
Okay, we'll need you to do that as well, but we'll take the.
So take them now?
Sure.
Thank you.
Oh, sorry. Okay.
Thank you. And we tried to organize the exhibits to tell the story, including pictures. This case does represent kind of an unusual fact pattern. First of all, we're submitting the Cleveland Department Board of Health Regulations, which talks about how a tattoo studio body art is supposed to be registered by the city. The first step is to obtain a certificate of occupancy. Mr. De La Rosa did that. Incidentally, on the city's website, it says, get the certificate of occupancy first before you make any investments. In other words, don't sign any leases, don't do any reconstruction, get the city's approval first. He did that, and it was approved on March 12th. On March 12th, he paid the fees to the city of Cleveland. I'd also point out the Ohio Administrative Code, the Cobb County Board of Health, and even the Hamilton County Board of Health defines body art to include tattoos. After he receives the city approval, He was ecstatic. This is his dream. He's been a tattoo artist for over 12 years. And he wanted to be in Tremont, the center of the art community in Cleveland. He signed a 2-year lease with my client, Cleveland Property Rental, which is owned by Dr. Chen. Dr. Chen is from Taiwan. Her family in Taiwan has a history of buying properties, living above those properties on the main floor, renting them out to commercial units to do business with the public. She was ecstatic to meet with Chris. He's an exceptionally smart young artist, and this is his dream to open up this space. He signed a 2-year lease with Dr. Chen, who, by the way, is a physician living in the city of Cleveland, and would do nothing to harm the health or well-being of either the residents of Lemco or the greater community. He signs a 2-year lease with Cleveland Property Rental and expose himself and assume the liability of $42,000 in rent over 2 years. He also spent upwards of $10,000 in developing the space, again, in reliance on the city's authorization to move forward. I also include pictures of the space in your packet, which you can see represents the pride and professionalism that he displays. Incidentally, it might be noted that, for the record, that his concept for this business is not like the business down the street, which is more like an urgent care for tattoos. Retail, you walk in, boom, you get a tattoo. Chris is a custom-made body artist. It takes hours and sometimes days to design a custom tattoo. He generally sees no more than one person a day. One person a day. Hardly the kind of traffic that would disrupt the residential community in the area. And I would argue it would enhance the area because of the quality of artistic talent that he has. April 25th, the city of Cleveland recants its earlier approval and says, whoops, you're in non-compliance. You're in violation of the code section saying that you can't operate within 1,000 feet of residential occupation, and you're within 1,000 feet of another tattoo parlor. This is after Chris has already spent over $10,000 in developing his space and incurring $42,000 in debt to his landlord. I also include this packet, Dr. Chen's profile, which is exemplary, and Mr. De La Rosa's profile, which is equally exemplary, including media profiles of him doing tattoos at various trade shows. Speaking of trade shows, it might be interesting to know at this point, it was 23 years ago the city of Cleveland did not permit tattoo parlors at all. Because of federal court litigation against the city under First Amendment freedom of expression rules, the city recanted and joined much of the rest of the country and said, you're right, tattoos are a unique form of self-expression. And sometimes it's a name of a deceased child. It could be something related to your military background. It's an indelible form of communication that represents the most intimate form of expression an individual has. As a matter of fact, in Japan today, they call tattoo artists maestros. Chris is a maestro. I also include in your packet a June 27th email from Councilman McCormick. This is his district. And he says, I do not have any inherent objective to this business. I also include the HOA bylaws from Lemco Hall, indicating that commercial units are distinct and separate from residential units. They're separate definitions. Commercial units are defined as street level, first floor businesses that are doing business with the public. Residential units under the HOA are defined as second and third floor units, which are reserved for residences. It should be noted that residential units can also engage in some commerce under city law. For example, a lawyer can operate out of a residence in certain circumstances. However, Under the HOA bylaws, a residence cannot be used for business unless it's in conformity with the city zoning and does not disturb the residential character of those units. Makes sense, right? If I'm operating a business on the second or third floor and customers are traipsing in and out, that's gonna be a problem. But not the problem on the first floor, city level, the street level. Those were intended from its inception over 100 years ago to serve the public. The HOA bylaws do restrict some businesses from operating even in the commercial spaces, the dirty dozen, if you will. So no porno shops, no massage parlors, no selling alcohol or food. There's no mention of tattoo parlors or tattoo studios in there at all. Obviously, they were listing them with some specificity on those that they don't want. They could have listed that. They chose not to. They chose not to amend their bylaws as well. This business would be consistent with the residential character of both the building and the surrounding community. It would not operate outside of 8 a.m. to 9 p.m., would not emit obnoxious sounds or smells, will not damage the reputation of the building or the community, and will not otherwise interfere with the enjoyment and comfort of the occupants. Now, I understand this board is empowered with the authority to grant a use variance of section 347(12)(b)(1) and B2 because, you know, we're within 1,000 feet of residential and 1,000 feet of a competitor. I believe that we do satisfy the requirements and the evidence would support this under 329.03 to qualify for a variance. The practical difficulty and necessary hardship under this fact pattern would be tremendous. Both Dr. Chen and Mr. De La Rosa have expended exorbitant amounts of time and energy to get to this point in reliance on the city's earlier approval. By the way, if the HOA appears to object today, that would be, again, kind of a shock because they didn't object. We didn't hear anything from them until Friday. Practical difficulty or necessary hardship in ownership to the peculiar premises of this unit. And Dr. Chen will speak to that. This unit is approximately 750 square foot. It is very small. On top of this size, it's broken up in a very uncommercial way. It's got two different levels. So it's about 500 or 550 square feet on the first level. Then you got a few steps to go up to the second level, which is about 200 square feet. What type of business would want that small of a space that's broken up into that area? Dr. Chen will testify. She's tried to rent this space to numerous tenants. Most of them are tobacco shops and vape shops. She's declined to rent to those individuals. Instead, she discovered Chris, and Chris said, yes, I but want to be the one to go in. And we thought that would be a better fit for the community and for the building. I would also say that denying this variance will deprive the owner of substantial property rights. She invested in this property based on the publicly published HOA regs that would permit this type of business. She rented to Mr. De La Rosa based on the reliance on the city's occupancy permit approval. And I would also argue that this approval of the variance will not be contrary to the purpose and intent of the zoning code. With that, I will conclude my remarks, but I would like to reserve time to respond to the HOA if they choose to object. Thank you.
Thank you, Mr. Herman. Before we move on to other comments, so what we typically do with a business is we want to know the hours of operation, how many staff members, whether you're going to be open to clients or you appointment only. So if you can go through kind of the logistical details of the business itself, that would be great.
Can I ask Mr. De La Rosa to address that directly?
Absolutely. Go ahead and tell us about how many staff members you're going to have, what your hours will be, days of the week, hours.
Sure.
And then will you have parking? And I'm missing something. Staff members, hours of operation, parking.
The amount of people that's going to
Yes,
be, okay.
and whether you're appointment only or.
We'll take it through it here.
Okay.
It's also, I just want to say good morning to everyone. Thanks for
morning.
having me. But yes, my name is Chris De La Rosa. So as far as the parking goes, we do have 6 available spots that are, we have the 2, I'm sorry, that are given to, like, that's allowed for the business. So there's 2 that's are adjacent from the property there. I'll be a sole acting artist there. So it'll just be me. Hours of operation is going to be between 11 a.m. and 7 p.m. typically. I typically work every day except for Sundays and Mondays. Yeah, realistically, being a private professional studio, like there is no like what people would consider walk-in traffic. That like a lot of people are accustomed to the idea of a tattoo shop being you can just come in, which some of those do exist, But this is intended to be a private studio to allow a more safe and private environment, for me to conduct my work.
So appointment only.
Correct. Yes, appointment only. Yeah.
Is that one person?
Yes.
All right, so no walk-in, so.
Yes. No.
And 2 parking spots, are those on the street?
No, they are adjacent. That would be literally.
We have 2 spots, one in the, the 6th lot I talked about, and we also have 1 indoor. That's
okay.
Yeah. But I just want to say there is sufficient amount of off-street parking in that area.
Okay, great. And anything else? So there will be no additional staff members?
Right, yes. Yeah, I'm the sole worker there. Yes.
And Mr. Herman, did you want to say something else?
I was just going to supplement, and Dr. Chen already said it, there's plenty of street parking, and the lot for the building is on Literary, right over in West 11th and Literary.
Right. Yeah, I'm very familiar with the area. I'm actually surprised you have parking at all. All right. It looks like we have a couple of folks on the phone. So we'll go to the Lemco Hall Condo Association next for comments.
Hey there. How are you?
Good. How are you?
I'm well. I'm out of state traveling for work, so I apologize. I can't be there. But yeah, I am representing the board, which represents the 11 unit owners. And I just wanted to, I guess, provide a statement towards this. And actually, I took some notes based on Mr. Herman's comments too. I might be able to provide some clarity, but that said, yeah, it is written into the HOA bylaws that there are those commercial spaces on the first floor. So we have an understanding of the makeup. The building was built in 1900. In 1999 is when the HOA was put into formation. A company had come in and kind of built these condos. So the total first floor is not fully commercial. There are two commercial units on the first floor. And there are 2 residential units on the first floor. And then there are 7 residential units on the second floor. So we have, I guess that understanding. That said, the intent of the building by the HOA bylaws is that it's meant to be a residential building. So there is comment or inside of the bylaws that says that the operation of a pool hall, nightclub, massage parlor, pornographic store, or the like. So Mr. Herman's correct. It is open to interpretation. But there is another declaration that requires all units, not all units, to be used as residential units with a couple of exceptions. An exception must be not being inconsistent with the residential character of the total condominium property. So it doesn't exclude or separate the commercial units within the bylaws. So that said, the board our attorney has sent communication to the unit owner and Mr. Herman, as I've been told from our attorney. And that was months ago at this point. Inside of our bylaws, it does state that the leases are required to be viewed. We don't have first right of refusal. It's nothing like that. But we are to review them a few days before they're signed. We did not receive those. So when I did speak with Miss Chen, I wasn't sure when she told me what was going in there because I don't know. Like we just live there. This is an uncompensated role being on the board. We just live there and are in a role voted in by the other residents to enforce these bylaws, right? So after speaking with our attorney, kind of came back that no, this does violate those bylaws and the residential nature of the total condominium property. And let me tell you, this is not easy to maintain and maintenance a landmark historic building. There's a lot that goes into it. And I don't know if any of you have ever been on an HOA board, but it's work outside of your normal work. But that said, I do want to touch upon a couple other things. I did mention again, one, there are 2 residential units on the first floor. They're both on the literary side. And then you have the law office that is on the corner, that corner unit that goes off to west. From there, I do understand the hardship of the split unit of that Mr. Herman had mentioned, that it is an odd space. And that's because the space itself is only 1 unit. It's supposed to be 1 unit. It's significantly larger than 700 and so square feet. There's a reason why I'm assuming that it was zoned years prior, as we had mentioned, as residential, because the original intent of the owners, I believe anyway, and this to the best of my belief and what I've read, was that it was meant to be a commercial where you live underneath it. So there is a residential unit in the basement underneath that unit, but to the bylaws in the condo, it's only 1 unit. So the previous owner, when Kimberly had purchased the unit, they had split it into 3 units and then sold it. I had explained that to Kimberly when she first kind of joined in, that it's still only 1 unit. So to be clear, that unit also, from that takes me to the parking conversation. That unit, by our bylaw, commercial units can ask for parking passes. We have just been giving every unit in the building 2. We don't have 22 parking spaces, to be clear. That said, the way that 1 unit is split up, that whole unit only gets 2 parking spaces. 1 is within the garage, and 1, it's not guaranteed. It's just a first come, first serve. We have that little lot. The address is actually 2365 West 11th. It used to be a gas station in the 30s. It's a very irregular parcel. But a lot of history here. But it's not a guaranteed parking space on those the 6 parking spaces outside. There is the one garage spot, but I believe her residential unit in the basement has been using that because his name is Paul. I've met him. He parks in the garage. So I just wanted to provide a little clarity on the parking, and I do agree with the sentiment of I'm surprised you can find street parking or off-street parking, because in Tremont it is an absolute it is a rarity. So we're all very happy to have it as owners and members of the HOA. Yes, so that's it. I just wanted to discuss kind of why the unit is fairly irregular, because it is technically 1 unit. It's not 3, according to the way that the HOA was built and the units are sold. It had just been made irregular by the previous owner when Kimberly purchased it. And then just clear up the fact that there's two residential units on the first floor and the parking. And then otherwise, the opposition to the zoning variance is simply that we feel that the board feels that a tattoo studio goes against the residential nature of the condominium property.
Great. Thank you for those comments. I just have one follow-up question before we move on to the next person. So can you please restate, I missed all the other businesses on the first floor. There used to be a yoga studio there and other things.
It's just
what is there now?
Yeah. Well, so it's just a law office. So the second unit number 2, which is 2337 West 11th, unit number 2 or apartment number 2, that's that corner unit that you see in the top right picture where you have that front door. They actually utilize the side door of that, but that is a law office. They do intellectual property law. It's owned by Sam Smart and John Yurga.
Okay, so only law office on the first floor, no other uses at this time.
So if you go down the literary side, those are 2 residential units you see down on there. If you go on the West 11th side, that next unit is owned by Kimberly. And that unit, while it's 1 unit to us and the HOA, it's been split into 3 and subleased out to 3. So technically speaking, it should just be 1 unit by our bylaws, but there is I don't know what the local beauty bar is. I don't know if it's eyelashes or something. That's been in there for, I don't know, maybe a year and a half or so. Kimberly would know better. She has the least specifics to, I just don't have it pulled up. And then there's a resident that lives underneath her unit, or that lives in her unit, but in the basement, that is residential.
Okay, thank you. All right, I'm gonna move to you then, really quick. So the picture we're looking at on the screen right now, there are 2 doors. Which one would be the tattoo business? Both doors?
No, it's the one in the middle, the
One in the middle,
bigger unit.
one. Okay,
Yeah.
okay.
And then the one on the left is actually esthetician. She's a facial, only does facial by appointment. And they see about 2, maximum 3, and it's not every day either.
Okay, so there's an esthetician business on the first floor. Okay, great, gotcha. All right, so we have well, I see that Miss Gregonis joined us. I'm not sure if she wants to speak today. We'll have to swear her in. But Ms. Gregonis, were you looking to speak today?
Good morning, Madam Chair and members of the Board of Zoning Appeals. Good morning. I'm Donna Gregonis, the Economic and Real Estate Development Director, and I can be sworn in.
Thank you. So please repeat after me. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please reply with I do. State your name and spell your name for the record.
I do, Donna Gregonis, Grigonis. Thank you.
Thank you.
And we'll go with your comments now, Ms. Gregonis, and then we'll move to you all here in the room. Go ahead.
So good morning, everybody. Thank you again for working with our organization, Tremont West Development Corporation, to work with the businesses, the city, residents, all of the people in between. So this is an interesting case because we just recently heard about it. We didn't know this was happening at all whatsoever, which is rare. I knew about the esthetician place months before she opened because she reached out to us. And then additionally, some of the other businesses that have been in this space, I've worked with quite closely. So I have been aware of the HOA and et cetera. And I actually spoke with the attorney last week of this case and did mention that, I did ask if they had met with the HOA. And I actually felt bad that they hadn't met with our office sooner because we probably would have been able to save them some time and money and at least being able to go through this process before having to come here and air all of this stuff out. So with that being said, we don't have a formal opinion on any of this. And we just feel badly that this was approved originally by the board or by the city and then rescinded. So I think it sent a lot of mixed messages. And I know that's not really anyone's fault, but an unfortunate case. So happy to answer any questions that I can and work with you guys however we can be helpful. And I'm not sure if this is productive, but it's honest. And it doesn't seem like it's a nuisance, but we would encourage everyone to go through the same avenues that other businesses do as well. And we defer to the city as well. So thank you.
Thank you for your comments. All right, we'll move to you. Do you have comments?
I can.
Go ahead and state your name for the court reporter, please.
Angelica Padron. If I can speak later on, as you guys ask if there's any hardships on him, I would like to speak
Sure. All
during
right.
that time.
Would you like to speak now, sir? We'll have you talking to the mic there. Go ahead.
Excellent. Thank you. Good morning, Madam Chair, members of the board. My name is Stephen Canarum. I am a colleague and a good friend of Christopher De La Rosa's, and I'm here to support my friend in the zoning variance for his business, Morningstar Collective. I've known Chris for approximately 10 years. We've worked together at multiple tattoo shops and trade shows together. And I've known him as a friend, known him as a colleague, and I've seen him put in countless hours, hardship hours, of making himself, his craft, better for his customers. And I can truly say he cares deeply about his customers and really wants to bring art and culture to Tremont and just contribute more to next levels. When I thought about giving a statement, I thought 3 words came to mind, 3 key features about this man. He's determined and committed, he's honest, and he's resilient. He's always faced challenges with all of his heart, and no matter if it's personal or within business, and he's always overcome. He's always pushed his skills to the next level, and him getting this spot makes sense for his line of work, for our line of work, and to make obviously Tremont even better. He's honest to where he speaks from the heart. I really felt he's always been transparent in all of our conversations, from if we've had food together or worked together, I've been at trade shows, I can always feel like he's very transparent, very honest. And I've always been very proud of him, to see him progress, and this looks like the next progression for him. Last thing is he's resilient. Everyone has hardships in life. But from what I see from a personal level, he's always overcome. He's always pushed through. He's always given 1,000% in everything he's done. And I'm just more than excited to see what this could become for him, for our industry, and once again, for the city of Tremont. So last thing I'll say is, if I was a business owner in this area, I'd be more than excited to see him open his shop, because I know it would elevate the businesses around that area, and his character would bring, nothing short of just enhancing, like I said, the city of Tremont, the arts, the cultures, and the trade of tattooing. Thank you for hearing me this morning, Board and Madam Chair.
Thank you. All right, Mr. Herman, would you like to speak before Mr. Herman? We'll give him a moment for a rebuttal before I open it up to our board. So
Could I speak?
Sure, go ahead.
Yeah, I just wanted to kind of address a couple things,
And just say your name first.
Oh, sorry, Kimberly Chen. I am the owner of the property. And as everybody has stated, I am a physician by trade, but I purchased this property just because the love of the space within Limco, and as well as the Tremont neighborhood. We all know Tremont's all about creativity, self-expression, entrepreneurism, and really accepting a person who they are. And that's the reason why we were so excited looking when this property was available. And what's kind of ironic, the property actually sat for over 2 years before it was eventually we purchased it. And I didn't really understand. And shortly after I purchased the space, and again, it was always listed as commercial. And even if you were to get a mortgage, you will not be able to get a residential because it's considered as commercial. There was nothing opposed by HOA, nothing at all. Other than after I purchased it, next thing you know, one of the tenant, the previous spot was owned by Vintage Stop. And she reached out to me and she said, the only way for you to survive is you got to change the HOA. And she specifically even named out Mr. Dilling. She felt that the place was harassed. For her store, she wanted to put a sidewalk sign outside just on the grass that people know it is open. And I believe they have worked with the Tremont West as well, and they have talked with the city and was, essentially was permitted. But Mr. Dilling continued to harass her, and then the owner, and then put a lot of block on ceiling of the other opportunity of that commercial unit. And then so when we talked about the hardship of the space, to rent it out, It is very difficult because number one, the size, and number two, the HOA restrictive government. And then number three, the harassment that that we get from the HOA, and really nobody except for Mr. Dilling. I have nothing but the most positive with the other board members. You know, they're always very kind, help out with the parking vouchers and the permits. And then Mr. Dillon continued to call me and harass me and ask me if we have reach out to their attorney. Then I said no. I said, well, he kept on saying, well, has my attorney reached out to him? The attorney has never reached out to me. And I also have checked with my attorney, Richard Herman, and he says, no, we have never gotten any notification from their attorney until this Friday, when Mr. Herman reached out to their attorney. So this is just another example of why it has been very challenging on renting all the space. I have showed the space for over 15 and more potential prospects. They range from, again, yoga studio, vape shop, convenience store, food prep, massage. I mean, I recognize because there's somebody living underneath, it's a residential upstairs. It has to be a very low volume business. That's why when Mr. De La Russo and I met, I was so excited. He is an award-winning tattoo artist. I mean, he gets tons of, first place, and I'm sure he can show you his accolades. And he explained to me his process. I mean, for any client come to see him, they first go through an online screening process, then followed by a multiple personal meeting sessions. And it's not just come in and do the tattoo. I mean, they talk about the design, they explore about the emotional, physical meaning and behind the tattoo. And then it is really a artwork and self-expression to help individual to overcome whatever the issues they have. I mean, as a physician, and I am an internist by trade, but I spend a lot of time doing telephonic mental health evaluations. What tattoo and just that self-expression can really help each individual who is really going through their tough time. You know, when you have a mom who died, how many people tattoo their names and a special design? I mean, that just goes to so much about that expression and the healing of that individual person. That's why, I mean, to call this as a tattoo parlor, I personally was very offended because this is really more a wellness counseling art expression in the form of a body as a medium rather than on the paper, which we all recognize is much harder than piece of paper. And it is a low volume, so I don't really understand why it doesn't even satisfy that residential requirement. But thank you so much, and I hope you understand what a hardship it is potentially for me and for Mr. De La Rosa.
Thank you so much.
Madam Chair, if I could say one thing. Our research shows that this property is not zoned residential, it's zoned retail, it's zoned general retail. Just for the record, just to help clarify how the board is reviewing this, it's not a residentially zoned property, it's retail.
Retail. Okay, great. Thank you for that clarification. All right. At this point, I will open it up to questions from the board. We'll get back to you.
Thank you.
Any questions from the board? Hearing none? Nobody has any questions? All right, Mr. Herman, go ahead.
Thank you, Madam Chair. Well, certainly in a normal situation, an HOA recommendation would carry a lot of weight in your decision making. I think this is a classic case where it should not. The HOA, Chris contacted Mr. Drayling and asked him to come and meet with him and tour the space to show him what he has built and what he wants to run. Mr. Drayling declined. Number two, I've never heard from the attorney until I contacted their attorney last Friday. And I said, you know, it sounds like your HOA is going to object. Can you please give us the basis? And then he gave me this letter, and I'll talk about that in a moment. I responded with a 12-page letter outlining the legal reasoning why he's wrong on the HOA bylaws. But we also invited the board to come and meet with Chris this weekend. And like Kimberly said, you know, the board has always generally been very supportive. What we hear is Mr. Drayling and barking, and you can't do this, you can't do that, you can't, you know, he wants to restrict entrepreneur. He doesn't have an objection to the aesthetician, but he has an objection to this. Why? He has less traffic than the aesthetician.
The law firm.
Or the law firm for that matter. It's discrimination. He doesn't like people with tattoos. He doesn't like tattoo parlor, you know, the studios. And that's illegal. That's discrimination. It's selective enforcement, and that's what could be litigated separately. It's something to do with the board. The board should make its decisions independent of this HOA, which I think is operating outside the bounds of the law. In regards to what Mr. Drayling said about the HOA regs, I'm assuming he's not a lawyer. And he's parroting what his lawyer said. And again, his lawyer's not here. That also indicates the level of commitment and communication from the board to the community. I asked the lawyer, by the way, to show us the board resolutions opposing this tattoo. Nothing's been provided. For all we know, it's just Mr. Drayling saying, I don't like it. And he's not asking the board members or the community members in the building. But I just want to finish up with his comment from his attorney saying that residential and commercial are treated the same in the HOA. They are not. And I've given you copies. There's a reason why commercial is defined separately and residential is defined separately, right? As I said, commercial is first floor, zoned for commercial purpose only, right? Residential is for living, and it's on the second and third floor, not the first floor, according to the regs. Then finally, this is the clause that the attorney, who's not here to argue, to represent his client, you know, he said basically this clause on page 27 conflates residential and commercial. By the way, his law office drafted this, I think, 12 years ago. It's poorly drafted, but it clearly makes the distinction between commercial and residential. Commercial, they keep citing this phrase, not inconsistent with the residential character of the condominium. That phrase is limited to residential units only. Commercial is treated differently. That one is, you can't sell food, you can't operate a porno shop, you can't do a massage parlor, right? Their attorney did not cite that provision, or he cited this other one, which is not relevant. Again, their attorney is not here today. So I would ask the board to take that into consideration. This tenant and this landowner is serious about this space and they're fighting for it. The HOA sends out a person who claims to speak for the board. But there's no board resolution, there's no meeting minutes, there's no attorney.
All right, thank you, Mr. Herman. I see someone has joined us. We'll, with their hand up. We're going to move this along. We'll need to swear you in, ma'am. Mr. Madison.
Sure. Thank you,
No
Abigail.
problem.
Abigail, do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please reply with I do, state your name and spell your name for the record.
I do. Thank you, Madam Chair. My name is Abigail Greiner. Last name is Greiner. Thank you for the time this morning. Thank you for allowing me to join this meeting, Madam Chair, and thank you for your consideration. I live in the greenhouse that is directly next to West Lemco, or Lemco Hall on West 11th. You can see it in the one picture there with the cars parked in front. I don't have any problem with commercial activity or economic development. I think it's great. The one thing that I will put out that I have not heard this morning mentioned is that Lemco Hall has residential garbage. They don't have commercial garbage at all. And so I understand that there are commercial properties in the anesthetician's office and also the law office. I have lived in my house for 10 years, actually probably 12 years at this point. And during that time, between my house and Lemco, there's a fire escape, and it's just to the left of the anesthetician office. And Lemco hauls all of their garbage for all of the residents, as well as any of the businesses that have been in there, are just in regular garbage cans under that fire escape steps, and get put out every week and brought in every week. And so there's no opportunity to dispose of any sort of additional or larger commercial trash. And so it's a concern of mine because I share that walkway with them. I have a dog. There's a gate there, and it attracts critters, quite frankly. So we have lots of visitors over there. So that's my main concern. I have not seen the bylaws of Lemco Hall to be able to speak to that. Also, I should say I am an attorney. I just happen to live in the house next door. I've not seen the bylaws for Lemco Hall, so I cannot comment on those. I have longevity in the neighborhood and know that the prior use, maybe about 2 owners ago, of this particular, the commercial units on the first floor, was an architecture firm. And so it was a business office for longer before I bought my house and until about, like I said, maybe 2 or 3 years ago, when they moved out. So the use is a little bit different, and I think that that's for your consideration for the board. And I obviously defer to that, but I thank you for your time. And I'm happy to answer any questions if there's any longevity questions or anything like that. So thank you for your time.
Thank you, Ms. Breiner. The only question I have is, so you mentioned the garbage. Do you have a request of this tenant with respect to the garbage? Is there, I hear there's an issue.
My request for Lemco is that they have commercial garbage, or that there is garbage maybe in a dumpster for all of the residents. I know that that's not necessarily economically feasible, and it's worked for the past 10 or 12 years how it is. I just don't know the amount of extra or what might be in garbage. And quite frankly, I'm going to put myself out there. I don't know what kind of garbage a tattoo shop might create. But that is what my concern is.
Okay, all right. So it sounds like, well, as the Board of Zoning Appeals, this particular garbage use isn't in our purview, but unless Ms. Leonard would like to correct me on that, but I don't think that it is. So my suggestion is that you work with Mr. Dreeling, Michael, with the HOA, and then also, if they are approved today, this tenant, to find a garbage solution that is more acceptable for both parties. But we hear, no one wants to create a situation where we have rodents and critters with garbage. So we hear your concerns, but it sounds like it's going to be two private parties working that out. Outside of the Board of Zoning Appeals. All right. Well, thank you so much for your comments. I'm now going to move to the city. Mr. Bay, go ahead.
Thank you, Madam Chair. My name is Xavier Bay, again, representing Cleveland City Planning Commission. We would recommend approval of the variances. As was mentioned, it's very low intensity, 1 staff member. The hours are from 11 to 7 p.m. I also mentioned this is a variance that we see in Grant regularly off a very similar basis, low intensity and appointment based. I also mentioned that we're planning to update our tattoo use literature in the zoning code to a more modern, a more modern description as studios, because they're very different than the historical perspective of tattoo studios being a place with very negative connotations. I think, and then also, this use is taking up vacancy. We like to see a lot of these commercial uses as well in this kind of a setting because you're bringing more eyes to the street. I'll also mention that this property is zoned general retail, so we could potentially see, a lot more intense uses here that would be a bit more disruptive to the nature of the residential mixed use character of this street and the neighborhood. For those reasons, we really support this variance. Thank you.
And then I just have one question, and this might be a question for our council. We have the zoning code, and then we have these bylaws. My understanding is that the HOA bylaws cannot be more restrictive than the zoning code. Is that correct?
I may have to defer to our zoning administrator, Shannon Leonard, to
Ms.
speak to
Leonard,
that.
can you weigh in on that?
HOA bylaws is not something we concern ourselves. That's a private matter. But in terms of the zoning is general retail, so a use variance isn't needed. It's just the separation requirements, variance that they are requesting. And if you want me to speak to the previous approval, I can do that as well.
The previous approval of the previous business here?
No, this specific applicant was approved, I believe.
Oh,
back in
yes, I
February or
would
March.
actually like to hear why they received an approval and then received a rescission of that approval.
Yeah, so the original approval was done by one of our plans examiners, that there was a little bit of a language barrier in the application. It looked more like a body art gallery. While that may be common terminology for some in the city of Cleveland, it's not always. And so there was a little bit of confusion. So he had gone ahead and approved it. Like I said, they don't need a use variance. It was just a separation. And it looked more like a art type gallery when he did the original review. Once it got to building and housing, the assistant building official flagged it, noting that it was for actual body tattooing. And so it got sent back to zoning, in which I wrote the letter of nonconformance for those separation requirements.
Okay, thank you for that procedural explanation. All right, if I don't have any other questions from the board, I think I'll entertain a motion, unless anyone has anything else to say from the board. No? All right.
I did, Madam Chair, wanted to reiterate or have the appellant reiterate what the hours of operation were, or hours of operations were, all of that, just for my notes to make sure I have everything correct.
You'll want to turn that mic on and
Yes, the hours of operation are intended to be 11 a.m. to 7 p.m.
that's every day except Sundays.
Sundays and Mondays I typically take off, but yeah, Tuesday through Saturday, yes.
Did you get that, Ms. Holzer?
I did. Thank you.
Okay. And just to reiterate, it's a private studio, appointment only, and no other staff members other than Mr. De La Rosa.
Madam Chair, I can make a motion.
Okay, it looks like Ms. Faith, or Ms. Kukla, I'm sorry, go ahead.
Madam Chair, I didn't hear the hours. I thought he had stated 11 a.m. to 7 p.m.
That's what he said.
That's what I said, yeah.
Yeah, 11 a.m. to 7 p.m. every day except Sundays and Mondays.
Gotcha. Thank you.
All right, I will entertain a motion.
Sure. Madam Chair, I move approval of calendar number 25-096. For the record, the appellant stated that the hours of operation would be 11 a.m. to 7 p.m. Tuesday through Saturday. It's a private studio by appointment only with only one staff member.
Thank you. Do I have a second?
Board Member Madison.
Oh,
A lot.
Mr. Madison beat you to it, Ms. Faith.
Sorry,
Board-
I'm quick on the buzzer today.
Board Member Madison, second.
Great. Ms. Kukla, will you call the vote, please?
Ms. Faith?
Yes.
Mr. Madison?
Yes.
Ms. Holzer?
Yes.
Ms. Roca?
Yes.
Calendar number 25-096 is granted. It'll be ratified next Monday. We will send the appellants a letter. You can contact us next Wednesday for further instruction.
Great.
Congratulations.
Thanks. Good luck with your project. Thank you for being here today. You too. Take care. All right. I believe that was our last case. So do we have any old business? All right, for those on the call, we're just having, everyone's just vacating right now, so we'll give them a moment to collect their belongings. All right, old business? I'm sorry, yes? I know, as long as you signed in, okay, yeah, we'll go ahead and have you sign in then. All right, back to you, Ms. Kukla. It's the Ms. Kukla show from here.
Well, on the screen, you see the highlighted items need to be ratified this morning. So it'd be item 1, 2, 4, 5, 6, and 8.
All right, any objections?
No objection.
No objection.
And then with respect to the affirmation, what is happening with this one?
This is the first affirmation request for calendar 24-220 at 1325 West 69th Street. Denny Matthew was granted variances in December to erect a new single-family residential addition. And he states that his architectural drawings are taking longer than he expected.
As someone who is dealing with things like that, I understand. So let's go ahead and any objections to this?
No objection.
No objection.
All right.
Then we just have your absence next week? Is that
Yes,
correct?
any absences to report other than mine, I will not be here next week. Next time you see me, I'll be a year older.
Happy birthday.
Happy early birthday.
Thanks,
Happy
everyone. All right, with
Okay,
that,
thank you.
I think we are adjourned. Thanks so much.
Thank you.
Well
everybody.
done, you guys. Nice job, Mr. Madison.
My trigger finger is getting a little bit better.
You were